It is, and I have received advice on this, it is unlikely, highly unlikely, that it would ever even get to the point of a complaint being considered and needing to be rejected, because under Section 17 of the Anti-Discrimination Act, it simply wouldn't fall under the definition of prohibited conduct. So prohibition of certain conduct and sexual harassment, Section 1, a person must not engage in any conduct which offends, humiliates, intimidates, insults or ridicules another person on the basis of an attribute referred to in section, and there's a list of sections, in circumstances in which a reasonable person, having regard to all the circumstances, would have anticipated that the other person would be offended, humiliated, intimidated, insulted or ridiculed. This simply, the example given by the member for Huon simply would not pass that reasonable person test. And to explain why I'm not comfortable supporting this particular amendment. Look, first of all, I think the community can feel comfortable and should feel comfortable. This idea that transgender and gender diverse people are sitting on the edge of their seat waiting for someone to use the wrong pronoun or use the wrong term or something that they're uncomfortable with so they can rush off to make a complaint is part of the reason why there is so much confusion and fear and stigma around this bill and around gender diverse people. Nobody's looking for an unwarranted or unnecessary complaint to make. People are not seeking to bring that kind of complication on their own lives. And I think part of our role as politicians and as decision makers in this community is to assure people that that's not what anyone in the community, the majority of people in the community are seeking to do. And there is nothing to fear from adding these protections and these terms into the Anti-Discrimination Act. Having said that, if there was somebody who wanted to make some kind of vexatious complaint, the Anti-Discrimination Act provides the Commissioner with the power to reject complaints, and the first reasons in the Act, so this is Section 64 of the Anti-Discrimination Act, Clause 1, the Commissioner may reject any complaint if A, in the opinion of the Commissioner, it is trivial, vexatious, misconceived or lacking in substance, or B, the complaint does not relate to discrimination or prohibited conduct. And it goes on with a number of other reasons, but I think those are the two most relevant. A person in a club on a Friday night saying ladies and gentlemen is not discriminating, it's not prohibited conduct. And should somebody feel they needed to make a complaint about that, I have no doubt that the Commissioner would reject that complaint under those two clauses. I think it's so important that we are sending the right message here in that people have nothing to fear. There is no reason for the community to fear that they are going to be held to some new standard where they need to hold transgender people to a higher level of respect than they do any other member of the community. That's what we're talking about here. So we won't be supporting this, or I won't be supporting this amendment.